Good morning, and thank you for joining me on the path to liberty. It's Monday, November 16th, 2020. And on this episode, I've got some quick answers to six of the top questions we get here about nullification and our strategy to get it done. Each answer really requires its own episode, so I'm just going to give you a quick take on it and reference to you, and I'll include some links in the show notes, some future reading for you to do, or additional episodes where I've covered that specific topic. I'm going to talk about the strategy, I'm going to talk about the Supreme Court, the supremacy clause, racism, federal funding, and a little bit more. But before getting to that, my name is Michael Bolden. We broadcast live every Monday, Wednesday, and Friday at 9:30 a.m. Pacific time from here in my home office and studio in downtown Los Angeles for the 10th Amendment Center. Our show homepage has everything you need to follow this program. We've got all the archives for over 2 years. And as you scroll through the page and look through all the different categories, I'm starting to actually organize into specific topic categories where you can just pick an issue that you want to see or listen to multiple podcast episodes on. So you just want to check that out. It's 10thamendmentcenter.com/path to liberty, all spelled out. You can also find all the platforms we're on. We've got video and live streaming and archive video versions. We have audio only podcast editions on Apple, Spotify, Podbean, iHeart, TuneIn, a bunch of others, to Stitcher and elsewhere, Google, of course. And even our membership program where you can support us for as little as $2 a month. That goes a long, long way to support the Constitution and liberty. Again, that's 10thamendmentcenter.com/path to liberty. And a quick hello to everyone out in the live chat. I want to give some shout outs here while we're waiting for people to get notifications to join us on the live stream. There's Patricia Dance. Good to see you. Funky Euphemism. Dixie Strong. Tyler, WC, I see Steve, Dan Reed, Melissa Harrell, Dennis Marburger, good to see you on a live stream again, Loki Luck, Alan Mosley, and everyone else. I apologize if I skipped over you. I'll try to get to some questions either later in the episode here or reply to them in the archive comments later on today. Again, thank you for being here. Let's dive into it. And again, we're talking about 6 of the main questions that we hear. There are many, many others, especially as you get down to the nitty-gritty technical aspects of how to draft the legislation, how it gets implemented, and things like that. But I want to first start out with, what is the strategy? A quick review. What is the strategy that we are using in most modern nullification efforts today? How do we bring down federal programs without asking the federal government to stop or start doing anything? And we really focus primarily on a paper that James Madison wrote in support of ratification of the Constitution in early 1788, Federalist number 46. I've pulled up an article that I wrote going over that paper in detail from 4 years ago, 2016. My government school math is terrible. You don't learn much in government-run education. Anyway, so the big focus of Madison's advice in Federalist 46, he was talking about concerns from the opposition that the federal government would just trample on the states and the people. And he's like, oh, no. The means of opposition to federal programs are powerful and at hand. And we focus primarily in our strategy on his advice to use a refusal to cooperate with officers of the Union, and legislative devices is what he called them in the state. So we're going to use legislation to ban cooperation of government officials on the state and local level from participating in the enforcement or effectuation of federal acts. And Madison put it this way: were the sentiments of several adjoining states happen to be in union, this would present obstructions which the federal government would hardly be willing to encounter. And as I went through in more detail last week, Wednesday's episode on how to nullify federal gun control, we recognize that most federal programs require a partnership between the federal government and the states to go into effect. And what's the little secret there? Partnerships don't work too well when half the team quits. Judge Napolitano told us in an interview a few years ago, he thought that a single state using this type of approach, just a hands-off, we're not going to help the federal government enforce this. A single state doing this on federal gun control would make that gun control nearly impossible to enforce. Our goal in the end run is fully impossible, but nearly impossible to enforce compared to what we have today is a huge step forward. So this is James Madison's advice in Federalist 46. Now, we can also take some advice from Thomas Jefferson. He wrote this letter to James Madison the day after the governor of Kentucky signed the Kentucky Resolutions of 1798. And surprise, surprise, that was November 16th, today in history, 1798. And here's how Jefferson put it to his friend Madison. He said, "I think we should distinctly affirm all the important principles they contain so as to hold to that ground in the future, and leave the matter in such a train as that we may not be committed absolutely to push the matter to extremities, and yet may be free to push as far as events will render prudent." Short version, we use Madison and Jefferson's strategy, all kind of combined, other people as well, Iredell, Patrick Henry, and others. But the general strategy is a refusal to participate in the enforcement of federal actions, and we recognize what Jefferson told us. We always want to hold the ultimate goal, the impossible to enforce, for example, but that it will take many steps to get there over time, and we should push as far as events will render prudent. That's a quick introduction, a quick overview of the strategy. If you go through 10thamendmentcenter.com/path to liberty, you'll see a few categories on nullification, for example, nullification essentials and strategies if you want to learn more. So what does the Supreme Court have to say about this? Well, this is the question number 2. Well, they've actually, and very surprisingly, reaffirmed Madison's advice over and over and over. Now, we know that nullification does not rely on the Supreme Court giving us permission to do something. We would have to actually push for it, even if the Supreme Court didn't agree. And in fact, that's what happens in most situations. The Supreme Court hasn't agreed to overturn or say that it's unconstitutional to have any of these federal gun control measures, so we have to actually take action in response to it anyways. But once in a while, if they get it right, it sure makes our path much easier. And the reason is because most of the people introducing legislation, well, most of the people on a state level who are responsible for whether or not legislation will ever even get heard or get a vote on or get out of its first stage, get a hearing, any of those things, are lawyers. And lawyers learn that the Constitution means what the Supreme Court tells them it means until the Supreme Court changes its mind. So this is a practical reality. So we want to also use strategies that can overcome obstacles from the so-called legal experts who really know nothing about the founding of the Constitution. But if we can cite something from the Supreme Court, it is very helpful. And there is one area where we can do that, and it makes life much less difficult when you're trying to undermine federal programs on a state or a local level. That is the anti-commandeering doctrine. If we take Madison's advice, a refusal to cooperate with officers of the Union in Federalist 46, and we say to a state, now we've got this legislation, we want to ban your cooperation on this particular thing with the officers of the Union. Well, thankfully, the Supreme Court from 1842 to 2018, in 5 major cases, there are a couple of minor ones all along the way as well, 5 major cases, has reinforced this approach, this state refusal to cooperate, as something called the anti-commandeering doctrine. And here's how Mike Meharry put it in a recent FAQ paper that we should probably get published here pretty soon, but here's a preview. Anti-commandeering, Mike writes, is a long-standing Supreme Court doctrine. In a nutshell, the doctrine prohibits the federal government from commandeering state personnel or resources for federal purposes. In effect, the federal government is constitutionally prohibited from requiring the states to use their personnel or resources to enforce federal laws or implement federal programs. And again, like I said, they started this out in 1842, where they reaffirmed Madison's principles in Federalist 46. But surprise, surprise, it's happened over and over and over again. And I actually did an entire episode on this early last year, February of 2019, anti-commandeering, the legal basis for refusing to cooperate. We also already have a moral and a constitutional basis, but getting past lawyers, you got to have something to back it up in law. Unfortunately, that's the reality, and that's where we're recognizing what Jefferson advised, not only in his letter to Madison in 1798, that we hold to the ultimate ground, but we push as far as events will render prudent. How far can we go? He also said in 1790 in a letter to Reverend Charles Clay that the ground of liberty is to be gained by inches. So we know know that it's going to be a long struggle to push back against the largest government in the history of the world, which has been growing in power, well, since day one. But significantly, of course, we know since the war between the states in the 1860s at that time, and then also 1913 was a pretty awful year as well for liberty. So anti-commandeering, the main cases are Prigg versus Pennsylvania in 1842, New York versus the United States in 1992, Prince versus U.S. This is the famous gun control case where they passed the Brady Act and they wanted to require local law enforcement to help the federal government implement the Brady Act. And there was a lawsuit by Sheriff Mack, Richard Mack in Arizona, who's been a longtime friend of the TAC. I haven't talked to him probably in about a year and a half, 2 years, so I definitely am due to reach out to Sheriff Mack soon. But Sheriff Mack and Sheriff Jay Prince, and I'm not sure if Sheriff Prince was in Montana or Utah at the time, but they basically sued and said, hey, you can't require us to do this. And they followed up on the 1992 case. It's almost as if they forgot about the 1842 case. The 1842 case was in essence saying, even if the federal government had this Fugitive Slave Act of 1793 on the books, we're not even going to address the constitutionality there, but you can't require the states to act as slave catchers for federal law. So it started that far back. So then we have the Prince versus U.S. case that was trying to require commandeer local governments into enforcing federal gun control. We also have NFIB versus Sebelius. This is the 2012 Obamacare case, one of the many. And the sliver of positive news on that was they reaffirmed anti-commandeering. They said that they couldn't even be forced to do something, even under the threat of losing federal funding, because that was considered coercive, because there wasn't agreed upon right off the bat. I'll get to more federal funding in a moment. And then Murphy versus NCAA is the most recent one. This was a sports betting case in New Jersey in 2018. And here Mike writes, the court held that Congress can't take any action that, quote, dictates what a state legislature may and may not do. They can't do anything to tell the states, and mind you, the states, the local governments are political subdivisions of the states, so they can't dictate to the states what they can and cannot do, even when that state action directly conflicts with federal law. Here's how Samuel Alito put it, quote, a more direct affront to state sovereignty is not easy to imagine. So that's what the Supreme Court has to say, at least about our specific strategy of using Madison's advice to refuse to cooperate with officers of the Union. That is, for those people who only care about what the Supreme Court says about the Constitution, and an unfortunate reality that we live under today, that's how most people look at things. We have something very powerful to back this up. I'll include that overview of the cases in the show notes and the article as well, which has a bunch of information on it so you can read and learn more. So you might be thinking, well, you know, that still doesn't make any sense, because what if it conflicts with federal law? Don't we have that supremacy clause? And we're not just going to rely on Samuel Alito, who is obviously not a consistent defender of the Constitution. We don't want to rely on him. But the supremacy clause isn't what the supporters of the monster state want you to believe it is. They want you to believe that when they pass a federal act, it is automatically supreme. All federal acts, laws, orders, rules, and regulations are supreme until the Supreme Court tells you it isn't. But that's not how things are supposed to work. And Mike Meharry, I think this was an article. Yeah, Mike did this in 2018. He answers the objection that the Supremacy Clause actually prohibits nullification. He says this probably ranks as the most common nullification objection. According to the naysayers, the Constitution's Supremacy Clause makes every federal edict the supreme law of the land. As such, and including edicts of the federal courts. As such, a state has no authority to challenge it in any way. And we'll hear that. We hear it less and less and less because we've been pushing this argument and educating people, and even our opposition really is recognizing this as well. Then they like to use it for their own pet projects, one side or the other, but that's another episode altogether. So the argument is that as soon as a state does something, they'll say, well, the courts already settled this, or the federal government already passed this. You can't do anything. But nonsense. We've got anti-commandeering. We've got Madison's advice. We've got the Supreme Court backing us up. And then, of course, once in a while, you'll hear this dumb argument about the supremacy clause. And Mike puts it this way. This erroneous assertion ignores the most important words in the supremacy clause itself. Only the Constitution and laws, quote, made in pursuance thereof. And if you are watching the video here, you'll see the text, if you can read it, where it's in bold. And it's not in bold in the Constitution, but we put it like that so it stands out because it's very important. If you think that all federal acts are supreme, you've basically only read part of the supremacy clause, but it specifically says only those acts which are made in pursuance of the Constitution. So in other words, they have to be following the delegated powers of the Constitution itself in the first place in order to be considered supreme. Those qualify as supreme. Any federal act, Mike writes, not in pursuance of the Constitution is, as even Alexander Hamilton put it, void. Now, he could have chosen any of a number of other founders to include, and I like that Meharry includes Hamilton in these situations because Hamilton was the big government guy. He was the monarchist. He wanted centralized power over virtually everything. He wanted the states to act as mere corporations, and he did flip-flop in order to try to get his way over time. It didn't take him very long. But even Hamilton, during the ratification debate, said if they weren't making an act that was expressly delegated to the federal government, then it would be void. So that's number 3, the supremacy clause. Number 4, the fourth question we get often is, well, who are you guys in the states to even have a question about whether or not something's constitutional? If you've got a problem with it, take it to the Supreme Court, of course, because the Supreme Court will decide constitutionality. The Supreme Court makes the final decision, and then they're just still kind of ignoring the facts on the ground that it doesn't really matter. But so here's how Mike puts it in his article. He says, even if they admit that federal actions violating the Constitution have no legal force, modern pundits will always claim that it's the Supreme Court's job, and in fact, they will claim it is only the Supreme Court's job to determine the constitutionality of an act, not a state. They usually refer to John Marshall's famous opinion in Marbury versus Madison to bolster their case. A quick aside, most everybody, pro and con, who talks about the Marbury case, they get it wrong. And if you just read the whole opinion, you can get a better understanding. I did an episode on that I didn't think of actually including here to show you or including the links. But if I can remember, I will include that when I publish the blog post on it later. But Mike writes, in effect, these people argue that the federal government determines the power of the federal government. So if the only people who can look at something and determine whether or not something is constitutional is the federal government or a branch of the federal government, because the Supreme Court is part of the federal government, then the federal government is determining the extent of its own powers. And Mike writes that Thomas Jefferson pointed out the absurdity of this notion in the Kentucky Resolutions of 1798, something I covered in a little bit more detail last week Friday. But here's how Jefferson put it. He says, the government created by this compact, so he's talking about the Constitution, the government created by the Constitution. That government didn't exist before the Constitution was ratified by the people of the several states, and it was ratified based on their understanding of the legal meaning of the document. And here's how Jefferson described it. He says, the government created by this compact was not made the exclusive or final judge of the extent of the powers delegated to itself. I mean, if you think about that, it is really absurd. The people fought a long, bloody war just years previous to this against the most powerful empire in history. They created the first of its kind, this written constitution for a confederation of states in the Articles, and then amended, well, they intended to amend it, then they wrote a new document, the Constitution for the United States. But the notion that the government itself could make up its own mind was one of the reasons of what its own powers were. That was one of the reasons for the revolution. And even in December of 1776, when things were looking pretty bad for it, Thomas Paine in The American Crisis, he reminded everyone, like, look, you can't turn back now. You can't change course. Why? Because the government that we are fighting against, we are fighting to separate from, is claiming the power to make decisions for us in all cases whatsoever. And in essence, that's the same thing. If the government makes the decision of its own power and the people have no say over it, then the government is the final authority over itself. And that is the definition of a tyranny. So the idea then is the government was not made the exclusive or final judge of the extent of the powers delegated to itself. Since, Jefferson put it, that would have made its discretion and not the Constitution the measure of its powers. It makes the goals, the political goals, the willingness, the backbone of the people in power, the willingness to go wherever they want to, the limit of their powers, not the Constitution. The Constitution is supreme, and that goes back to the idea of the supremacy clause. The federal government is only, their federal acts are only supreme when they're following the Constitution, because that Constitution is supreme. Now, mind you, because we're using the anti-commandeering doctrine, and here this is to Mike's soon-to-be-published FAQ on anti-commandeering, since we're using anti-commandeering in a refusal to cooperate, we're actually doing an end run around questions of constitutionality. We're not even, I mean, I would like to see more and more people and states and local governments looking at a federal act and saying it is our position in this state that that federal act is unconstitutional. Or maybe passing a resolution saying, here's a list of all the unconstitutional acts from the federal government. This is basically what they did in response to the coercive or the intolerable acts leading up to the revolution. It's what they did in response to the Stamp Act as well. And the protest, they gave a list of the things that they saw as a violation of their rights or as unconstitutional in regards to the unwritten British Constitution. And they said, well, here's basically notice and demand that we will not submit to these. And they've got to go or something's going to happen. And so I would be on board with a state actually saying that, or a local community passing a resolution saying this is what is got to go. And then when you don't do it by this particular date, which is basically the strategy they used in response to the intolerable acts leading up to the revolution, if it doesn't go by this date, then we are going to take this action. We're no longer going to help you enforce it, for example. And then if it still doesn't go, then we're no longer going to do this, and on and on and on. And that is really the strategy. Now, anti-commandeering, a refusal to cooperate, doesn't depend on something being first determined unconstitutional. And in fact, James Madison told us that specifically in Federalist 46. He said this strategy, the states and the people had very powerful measures at hand, tools at their disposal, whether they saw a federal act as warrantable but bad policy, that means within the bounds of the Constitution, but just something that the people don't like, or unwarrantable, that is outside of the Constitution. They just don't have to participate. And that's in essence what the anti-commandeering doctrine is all about, and that's why it becomes so much easier that we don't have to fight these other legal debates on every single question, because it's very, very straightforward. It's not even if it's the claim is that they're authorized to do anything and everything. Well, if the states don't help them, doing everything and anything and everything becomes nearly impossible. And that's how Mike put it. He says the short answer is it doesn't really matter in the legal impact of a nullification bill that uses anti-commandeering, whether or not the federal act is unconstitutional. Of course, there's so many on the books that it's basically everything they do is unconstitutional. So as soon as you stop participating, that's the case anyways. But we're not really waiting on that determination. It's not part of the equation. He says the anti-commandeering doctrine doesn't depend on a finding of constitutionality. States can refuse to provide personnel or resources for any federal activity, regardless of constitutionality. The utilization of state resources, funds, and personnel are totally at the discretion of the state government. So the next question then, and I did an episode on determining constitutionality that I thought would actually be good to revisit. It's James Madison's view on interpreting the Constitution. The short version of this is that everyone who takes an oath to the Constitution, they take an oath to the Constitution. They aren't taking an oath to the Supreme Court opinions. They aren't taking an oath that says, I, swear that I will follow what the current practice is on constitutionality until some judges tell me to do it differently. That's not what it is. Everyone, according to James Madison, Thomas Jefferson, others, has a moral and a constitutional duty to follow their oath according to how they believe it applies. So if you believe that your oath tells you that to regulate means one thing instead of all human interaction, you have to follow it according to your own belief. And then if you don't do a good job according to your constituents, they're going to get rid of you or resist your actions. So Madison himself actually believed that everyone had a duty to follow the oath according to the best of their ability, to their best understanding, and that's how you weed out the garbage. You don't just wait for an oligarchy, 9 unelected, unaccountable, politically connected lawyers to base it, and it wasn't 9 at the time, it was 5, but it wasn't, you can't just wait 2 or 4, 6 years for someone to tell you what the Constitution means or not. It's just not how it's supposed to play out. I'll include a link to that episode in the show notes so you can check it out as well. Now, the next one I want to talk about is racism. And some people, we heard this a lot during the previous administration in D.C., that if you wanted to use nullification, you had to be a racist, you had to be a neo-Confederate, you supported slavery, and the like. And then, of course, those arguments pretty much went away the last 4 years, and instead we were commies and libtards and things like that. But the short version is, I expect the whole racist garbage to come up again. And people will say, well, isn't just a nullification just code word for racism? Well, let's briefly mention that in the 1850s, every northern state took actions using this anti-commandeering approach primarily. There was a little bit more aggressive action happening in Ohio, a little bit in Wisconsin, a little bit in Syracuse, New York, and some jury nullification, breaking people out of jail and things like that. But in general, the approach was anti-commandeering, a refusal to cooperate with officers of the Union regarding the Fugitive Slave Act of 1793 and then again of 1850, and specifically regarding nullification of the Federal Fugitive Slave Act of 1850. This was primarily done by every single northern state. And then, of course, in modern times, we now have, as of just this month, we now have 36 states defying, undermining, refusing to participate in some cases in a very narrow area and in some areas a very broad area in enforcement of federal prohibition on a plant. And then if you want to talk about it as well, we have 300 some odd localities, whether you love them or hate them, we have 300 some odd localities that are refusing to help enforce federal immigration laws. Most places it's very narrow. Some places like San Francisco, Oregon, and throughout California, it's very broad. So if you want to call nullification racist, because people like me think that this same strategy should also be used to stop federal mandates on health care, federal prohibition on your right to keep and bear arms, to undermine and defeat the Federal Reserve, and all kinds of other unconstitutional federal programs, I can't stop you. It just means that you're a liar, because you can't actually look at nullification as a tool and how it's been used through history. Almost every single time it wasn't in support of racism. That is a lie. That's what I was taught, of course, as well. I think that's what we all learned, because I think the people who support centralized power, they don't want people to think that something positive can come out of decentralization. So no, nullification is not a racist tool. And even if some people who are that have used it or tried to and failed to use it in the past, in general, it has been totally the other way around. And then the last question I want to cover is a pretty common one as well. Hey, aren't the feds just going to come and cut federal funding? We hear this one actually probably more often than anything, and we hear it from both sides of the political spectrum, because in general, a lot of these arguments come from one side or the other. Well, it usually comes from the party in power. They'll come up with tons of great reasons why you can't do what you want to do. But one that we hear all the time, and we'll hear this from skeptics, we'll hear this from people who are just cynical, like, you can't even try this. They're just going to come and take away all your federal highway funding. And in one case, actually, I saw a conservative blogger, or I guess celebrity, I don't know what the guy is. I can't even find his name. Ryan Fournier. He actually cited a Supreme Court case, South Dakota versus Dole, from 1987 to claim that, oh, if the states get uppity and they try to defy federal acts, then the feds can just come in and take away all their funding on, for example, highways. And that's one that we hear all the time. But what they're actually doing is they're ignoring almost the entire case, and they're hoping that you don't know anything about it as well. And here from my article on this, this looks like April of 2018. Although the Supreme Court upheld the federal law in question, so Congress was actually trying to withhold 5% of highway funds from states that did not raise their drinking age from 18 to 21. 5%. They weren't trying to take away all the funding. They weren't trying to take away funding from another area. And then, of course, we're setting aside the fact that the money that they're using for, quote, funding is all done through stealing and violence in the first place. That I'm going to set aside. But what the law in question from Congress was, if you don't raise the drinking age to 21, we're going to take away a small portion of your federal funding. So that gets twisted into the feds will take away all your federal funding on highways, for example. But even though the court upheld the federal law, it came with specific limitations. One was a requirement that the amount of funding could be seen only as an inducement and not be, quote, so coercive as to pass the point at which pressure turns into compulsion. So you can do kind of a carrot versus the stick thing on somewhat closely related things, not totally unrelated items, as a carrot versus stick. Like, well, you're going to get a little extra benefit, but if it becomes so great, it turns into unconstitutional coercion. What they are called was a constitutional gun, an unconstitutional gun to the head. Now, in this case, a withholding of 5% was seen as below the threshold. As the court noted, this, quote, constituted less than half of 1% of South Dakota's budget at the time. So anything more than that, and that's what happened in NFIB versus Sebelius. Hey, you guys need to expand your roles or you're going to lose federal funding. Well, no, that was seen as an unconstitutional gun to the head. It was seen as unconstitutionally coercive funding threats, and they're not authorized to do it, even in a bad case like NFIB versus Sebelius. Additionally, the court held that funding conditions on the states must be reasonably related. For example, taking away a law enforcement grant over a violation of an environmental regulation would likely be considered unrelated and unconstitutional. It's a gray area, but the case that people cite on this actually tells the opposite story of what the story they want you to believe. And the one they want you to believe is that the federal government can do whatever it wants, whenever it wants. And if the states try to do something different, they're just going to take away funding. They're going to continue stealing the money from people, but they're going to take away the funding. Well, we know, at least if it goes to the Supreme Court, that's not how it's going to play out. So the states, as long as they hold fast and resist that, they're going to win on the ground and in court. And one quick bonus question is, hey, dude, does this work? And I just want to reiterate this. I know if you've watched or listened to any of these shows recently or over time, absolutely. In fact, I believe this is the only way forward. A refusal to cooperate on an individual, a local, and a state level, because going to the federal government to fix problems created by the federal government not only is just bad strategy, it is resulting in the largest government in history that keeps growing no matter which political party, which person is in power in D.C., and it's going to be up to the people of the several states to resist all their usurpations, or nothing's going to change. We cover the status of the modern nullification movement in our annual State of the Nullification Movement report. It's 10thamendmentcenter.com/report. I don't have that up on the screen, but I will include that as a link to the show notes. In the show notes over at 10thamendmentcenter.com/path to liberty. Just taking a quick look over at the live chat for a couple minutes. I see some interesting comments. Funky Humanism said, people brought slave catchers before courts, seeing slaves as prisoners and using habeas corpus to force the slave catchers, being seen a jailer to justify the whole, talking about the Fugitive Slave Act. There was a lot of resistance. They would grant habeas corpus. They would grant people a jury trial when the federal government said they weren't allowed to do that, for example. Clay Kent says, stop banning the plant from adults, no doubt about it. Erwin Havernick says, I'm nullifying Dr. Fauci. You know, at some point, whether you agree with what they do or not, sooner or later, people need to start living the way that they see as best for them, living as free as they can, whether or not government tells them it's okay or not. Now, it always comes with risk. Again, that goes back to Jefferson's message on November 17th, 1798. We should affirm all of our top principles and affirm all the principles of the Kentucky resolutions of 1798, he was saying, but leave the matter in such a train as that we may not be committed absolutely to push the matter to extremities. We don't want to always push it to extreme. We don't want everything to be a hill to die on, and yet may be free to push as far as events will render prudent. I will take a look through the live chat and answer as many questions as I can later today. I do read through all of them, so please continue leaving comments, whether it's live right now or later on the archive. I read through all of them. I don't get a chance to reply to a vast majority of them, but I do where I'm able to. You can also email me, team@10thamendmentcenter.com. if you've got questions or suggestions for a future episode. If you enjoyed this, if you learned something, which is I hope you learned something. If not, I hope it was a nice refresher of stuff you've already been aware of. But if you like the episode, please do a few things to help me spread the word. That is, smash the like button on any platform you're on, leave a comment, leave a review, especially on Apple Podcasts, Podbean, and elsewhere. All those reviews and these other actions tell the platform's algorithm to show the program to more people. So that is incredibly helpful in getting us to reach new people with this message in support of the Constitution and liberty. And of course, if you want to help us do that, join our membership program today for as little as $2 a month over at 10thamendmentcenter.com/members. Again, I hope you enjoyed the episode. I hope you learned something that's more important than anything. I hope your Monday is off to a good start and you had a great weekend, and I'll see you next time here on the path to liberty.